You've been meaning to finish your estate plan for 3 years. Your spouse has been asking. You've closed the tab every time you Googled it. You tell yourself you'll get to it, but you haven't gotten to it. And somewhere in the back of your mind, you know that if something happened tomorrow, your family wouldn't know where to start. You're not alone. The average American has been meaning to create their estate plan for years before they actually sit down and do it. This video is your nudge to take that next step. I'm Andrew C. Goodwin, the principal attorney at Rhodium Law. I help Ohio professionals, business owners, and their families craft the estate plan they've been meaning to put in place. Estate planning has deep personal significance for me. You see, I didn't set out to become an estate planning attorney. After working in IT for well over 15 years, I spent most of my legal career working for a large law firm and as in-house counsel to a global health system, drafting, reviewing, and negotiating complex commercial agreements. But in the early days of the pandemic, I started to notice that things were changing with my mother's ability to remember things and take care of herself. Having been through a dementia journey with my father, I knew firsthand the cost of incapacity when financial and medical decisions hadn't been made in advance. So I laid down my career goals to become her full-time caregiver. I spent over 5.5 years as her primary caregiver during that season. I struggled to find the right legal counsel for my family, so I began to learn estate planning and elder law the hard way, all while trying to hold my family together. I understand what keeps a lot of us from getting a plan in place, and I also know what happens when we fail to plan. That's why I built this practice, and that's why I'm making this video. Here's what the data says. Only about 24% of Americans have a will. That number has actually dropped in recent years. It used to be closer to 40%. And even among professionals earning over $150,000 a year, only about 15% have an up-to-date plan. So if you don't have an estate plan yet, you're in the majority. You are not lazy, and you are not irresponsible. The real reason most Ohio professionals don't have a plan is simple. The legal system makes it confusing, intimidating, and it's a slow process. Many people close the tab because what's on the other side of the tab is jargon they don't understand and billing that they can't predict. This video exists to fix the first part of that. I'm going to explain in plain English exactly what an estate plan is, why Ohio is not exactly a forgiving state on this topic, and what your family faces if you don't have a plan in place. No law school vocabulary, no pressure, just the information most Ohio families never get. First, let's start with a definition. An estate plan is a set of legal instructions that answers 3 basic questions. 1. Who gets your stuff when you pass away? 2. Who makes decisions for you if you can't, both financial and medical? 3. How to keep your family out of court and out of conflict during the hardest moments of their lives. That's what an estate plan can do. Now, when you actually sit down to build one, every plan has a foundation. And for almost everyone, that foundation is one of 2 documents. Option 1 is a will-based plan. Your last will and testament is your voice after you're gone. It tells Ohio who gets your property, who raises your minor children if you have them, and who's in charge of settling your estate. If you don't have a will, Ohio law writes one for you, and we'll get to what that actually means in a minute. Option 2 is a trust-based plan. A revocable living trust is a legal entity you create and fund during your lifetime that holds and distributes your assets. You stay in full control of it while you're alive and well. When you pass, or if you become incapacitated, the person you name steps in and administers it according to your instructions. No court, no probate. We'll dig into when a trust actually makes sense later in this video. And here's a quick clarification people sometimes get tripped up on. If you go the trust route, you still have a will. It's a specific kind called a pour-over will. Its job is narrow. Anything you didn't formally title into the trust during your life gets poured over into the trust at your death, so it's still governed by your plan. Think of it as the safety net under the trust. Whichever foundation you choose, the plan isn't finished there. Every comprehensive plan includes 4 more documents that handle decisions while you're still living and access when things go sideways. First, a financial power of attorney. This names the person who can handle money decisions for you, either right away or if you become incapacitated, paying bills, managing investments, accessing accounts. Without it, your family may have to petition a court for guardianship just to write a check on your behalf. Next, healthcare power of attorney. This names the person who makes medical decisions for you when you can't make those decisions for yourself. When someone is legally incapacitated and can no longer make binding legal decisions for themselves, it's essential to already have the right person authorized to make medical decisions for them. Having this document in place helps keep families out of a court fighting about who gets to decide. Next, a living will. This one is separate from the healthcare power of attorney, and people sometimes confuse the two. The healthcare power of attorney names the person. The living will states your wishes, specifically around end-of-life care, life support, and the measures you don't want taken if there's no reasonable hope of recovery. One is the who, the other is the what. Finally, a HIPAA authorization. Short but important document. This tells hospitals and doctors who's allowed access to your protected health information. Without it, even your spouse may be blocked from getting an update on your care. So, a will or a trust as the foundation. A power of a will if you go the trust route, and for every plan, a financial power of attorney, a healthcare power of attorney, a living will, and a HIPAA authorization. That's the floor. If you don't have it in place now, your family is exposed. Before I talk about what Ohio law does to you if you don't have a plan, I want to clear up 3 things I hear constantly. Misconception 1, estate planning is only for the wealthy. That is not true. If you own a home, have a savings or retirement account, or have people depend on you, you have an estate. Ohio probate doesn't care how many zeros are in your net worth. It takes the same cut either way. Misconception 2, I'm too young to need this. I've had clients in their 30s who needed an estate plan urgently. Young parents, people with minor children, people with a home and a mortgage. Estate planning is not about your age. It is about whether other people depend on you and whether you want to be the one who gets the final say about what happens to the life you built when your night comes. Misconception 3, my spouse gets everything automatically, so I don't need a plan. This one is especially dangerous. Under Ohio Revised Code Section 2105.06, if you die without a will and you have children, especially children from a prior relationship, your spouse may not inherit everything automatically. The law splits your estate according to a rigid formula. Most Ohio couples have no idea. If any of those 3 beliefs sound familiar, you are exactly the person this video was made for. Let me talk to you about what actually happens in Ohio when someone passes away without a plan. This is the part most people don't know until it's too late. When a person dies without at least a will in Ohio, the state's intestacy laws kick in. Intestacy is just a legal term for dying without a valid will, and it means Ohio decides who gets what, not you. Ohio applies a rigid formula. Spouse first, then children, then grandchildren, then parents, then siblings. The formula doesn't care about your blended family. It doesn't care about your estranged brother. It doesn't care about the grandchild you specifically wanted to provide for. Ohio doesn't know your life. That's not a criticism of the state of Ohio. It's just what a formula does. Then there's probate. Probate is the court process your estate goes through before your family can actually inherit anything. In Ohio, probate generally costs about 3 to 7% of the total estate value on a $1 million estate. And by the way, that's the number many Ohio professionals reach by their 60s. Between a paid-off home, a funded retirement account, and life insurance, that's generally $30,000 to $70,000 lost to court costs, executor fees, and attorney fees, plus at least 6 to 12 months of delay. During that time, your family cannot sell the house if you passed away with it only in your name. They cannot touch the frozen accounts that were only in your name. But the mortgage, the taxes, and the insurance keep coming due. And it gets worse. Studies show that approximately 58% of families without a proper estate plan experience disputes. Poverty rates for widows between the ages of 51 and 64 approach 20%. The person who spent a lifetime providing for their family may end up leaving them feeling unprovided for, not because they didn't care, because they didn't plan. I know what some of you are thinking. Okay, I hear you. I'll just use LegalZoom. I want to be fair about this. DIY online estate planning document services include some legitimate companies. They are affordable, and for very simple situations, they may work just fine. But here's what the research shows. Studies generally indicate that approximately 80% of do-it-yourself legal forms are completed incorrectly. That doesn't always mean catastrophically wrong. Sometimes it's a signature in the wrong place, a witness requirement missed, or a trust that was drafted but never actually funded. The problem is that your family won't find out about the mistake at a convenient time. They find out at the worst possible time, when a bank refuses to accept the document, or when the court requires a formal probate anyway because the trust was never funded. I'm not here to talk anyone out of a DIY approach if your situation is genuinely simple. I am here to tell you that the real cost of a DIY plan is not what you pay today. It's what your family may pay later. Make that decision with your eyes wide open. One of the most common questions I get is this: what's the difference between a will and a trust, and which one do I need? Here's the plain English version. A will is a document that tells Ohio what to do with your stuff after you die. It is simple, it is well understood, and it is cheaper to draft. But it has one major limitation. A will has to go through probate. That means the public record, the 6 to 12 month timeline, and the 3 to 7% fee we just talked about for Ohio residents. A trust, on the other hand, is a legal arrangement that holds your assets during your lifetime and passes them to your beneficiaries after you're gone without probate. A properly funded living trust is designed to keep your estate out of probate entirely. Private, faster, no court, no frozen accounts, no public record. So which one do you need? Honestly, it depends on your situation. For many Ohio professionals I work with, the answer is both. A trust as the main instrument and a portable will as a backup to catch anything that wasn't funded into the trust. But for someone with a very simple situation, no real estate, no blended family, no significant retirement assets, a well-drafted will may be all you need. The key word in that last sentence was well drafted. If you decide you need a plan, decide whether it's going to be drafted by someone who understands your situation or filled in some blanks on a website. Those are your two options, and they do not produce the same outcome. I want to close with two pictures. One is what this looks like when you finish your plan. The other is what it looks like if you don't. If you finish your plan, here's what changes. The open loop that has been nagging for years finally closes. Your spouse stops asking you. You become, in your own head, the provider who handled it, not the provider who meant to get around to it. If the worst happens, your family grieves, but they don't also spend 6 to 12 months in an Ohio probate court arguing over what you would have wanted. They know where the documents are. They know what to do. You gave them that clarity. If you don't finish your plan, the Ohio Revised Code has already written one for you. Your family learns what intestacy means. Probate costs take that 3 to 7%. The assets may freeze for 6 to 12 months. And the people you spent your whole life providing for may spend the first year after your death fighting over what you would have said if only you had said it. This is the part most estate planning videos don't tell you. Estate planning is not just about preparing for when your night comes. It's also about applying your work ethic to that last act of love. The same work ethic that built your home, funded your retirement, and raised your kids. It's about being the kind of person who finishes the job of protecting what matters most. If you found this helpful, please subscribe. I publish videos every week on Ohio estate planning topics, all in plain English and all focused on what Ohio families actually need to know. I've also put a free resource in the description below, our plain language guide called The Ohio Probate Trap: What Happens to Your Home, Your Retirement, and Your Family If You Don't Have a Plan. It covers everything we talked about today in more depth, and it's free. One last thing. I am an attorney, but watching this video does not make me your attorney. This video is merely general information and does not constitute legal advice. If you are ready to finally get an estate plan in place or seeking assistance with updating an existing plan, please contact an attorney who will review and discuss your specific circumstances. Strategize, secure, shine. I'll see you next time.